I'm warning you, never work without a contract. I've said it before in videos, and I'll say it until the day I die. You need a contract if you're doing work. Even if you're doing free work, you should be using a contract. Definitely model release. A model release is a form of a contract. A contract is simply an agreement. You're saying, here's what I'm going to deliver, here's what you're going to get, here's what you're going to give me in exchange for what I'm going to deliver. It's that simple. But I see people telling people not to use a contract because they don't use a contract. Don't take that. Like, that's the worst advice you could ever get or give someone. So recently, my friend Eric has said to me that he wants to start taking this more seriously, and he's starting to use Sprout Studio. That handles all the booking process, the contracts, payments, everything, all within that system. So I sent him over a copy of my contract. What I use, there are contracts that are built into it, but he said, hey, is this good? It's fine. My contract, like most contracts, is written in blood. My contract, there has clauses in it that are clauses that I've found online that I'm like, oh, that's smart, I should have that. And other clauses that are like, I've been burned by this, so I need to add a clause into my contract that addresses this situation. And I'll talk about it. I'm going to go through everything bit by bit, and I'm going to explain what it means, why it's there, and why I have it there. I'm not going to tell you that this is a contract that you should use. I'm not going to tell you anything because I'm not a lawyer, and a little disclaimer, this is not legal advice. So we'll start there. I'm not a lawyer. This is not legal advice. This is just my contract. This is the contract I use. I will also say that all of the text in this contract I have found from other sources that I have not paid for. I have not paid for copies of contracts from anyone. These are all text that I have found in other contracts online. So I'm going to go through my entire contract clause by clause and line by line. And so buckle in, because this one is going to be exciting. So in order for a contract to be legal, you need the names of the parties, you need the signatures of the parties, you need an explanation of what the contract is, and you need a date. The very first thing at the top of my contract is the date of the contract. What you're going to see here as well is you're going to see some variables only on this page that are in brackets, square brackets, and those are variables that are used by the Sprout Studio system, and they are automatically replaced and updated every time the contract goes out. So these variables are updated with the client information, my brand information, the details of the package that we've agreed to for that, and the payment schedule, and whatnot. So we'll go through. So contracting parties. These are the two parties who are entering into this agreement. And it says this agreement is made and entered into between client name, client address, phone number, email, and business name, business address, business phone number, business email, hereinafter referred to as the creator. That is me. I am the creator. And so anytime you see the creator referenced in the contract, that's referring to me. Job description, job date with the shoot date, and job time, the shoot time. The details, which include the package that they've ordered, what's included in that. It's all put into the contract automatically by Sprout Studio. And then the payment schedule, whether there's a deposit on that. So for a wedding, there might be a 50% deposit, and then a payment of 25% later, and a final payment of 25% later. Or there might be a deposit, a flat fee deposit of $1,500 or $2,000 or whatever that is. The balance is automatically calculated out by Sprout and the payment schedule, and it's all put in there. And then there's a little box that says accept, and that puts a checkbox into the contract that they have to click on to show that they have agreed to those terms. If that box is not clicked, they can't sign the contract. Then we go on to the terms and conditions, and we start with the agreement. And this clause basically says that the contract is an agreement between the above referenced creator, that's me, and the undersigned client, herein known as client, or agency representative, herein agency, constitutes the entire agreement between the parties. The fees and expenses are based on the job description as presented by the client or agency and summarized herein. That's why we had the job description in there previously. That is referencing that information. What this is saying is that the agreement is between me and a client, or me and an agency representing that client, and this agreement is the entirety of the agreement. This is it. This is all of it here. Everything that's laid out here. In the event that any part of this agreement is found to be invalid or unenforceable, the remainder of this agreement shall remain valid and enforceable. So if a clause, if the laws change and a clause has been deemed to be unenforceable, that doesn't void the entire contract. It will just void that little clause, and that's it, in that little part of the agreement. Any agreement to waive one or more provisions of this agreement, or any failure by one or both parties to enforce a provision of this agreement, shall not constitute a waiver of any other portion or provision of this agreement. Same thing. So if we decide, okay, well, we are agreeing that this part of the agreement, we are going to waive that. That doesn't mean we're waiving the entire agreement. We're just agreeing to waive that part of the agreement, and it won't affect the rest of the agreement at all. Any changes, whether made orally or in writing, may result in additional charges. And this is important because if there are changes made to the scope of the project and they require more images, the price that's set out and the details that are listed in this agreement may result in additional charges. They likely, if the scope is increasing and they need more images, there are going to be more charges. What this does is say that just because you change the scope doesn't mean you get to keep it at the same price. The expenses outlined in the agreement are estimated in good faith, and a 10% variance applies to project total of 10%, like leeway of 10%. So if an agreement, to use a round number, is for $10,000, that means we can have a variance in the final cost up to $11,000. Anything beyond that, then we want to change the agreement. We want to redo the project details, the project scope, and we need to get it signed off and get a new contract updated and have it done on site during the shoot and get that going at that time. Sales tax is not included in the estimate. Any applicable sales tax will be added at the time of the invoice, and estimates are valid for 15 days. The estimate that they're getting and the price that they are agreeing to does not include sales tax. Sales tax should be calculated at the appropriate level and passed on to the client. The next section is definitions, and this is a longer section. This is the longest section of the agreement because we need to spell out exactly what it is the terms mean within the contract. Actually, I took this section of the video and I put it in its own video, which I released right before this. So if you haven't watched that video yet, go back and watch that. It deals with all the definitions and terms that exist within this contract. It was such a lengthy portion of the video that I decided it would be better on its own. So go check that out and then come back and watch this. And this video will be linked at the end of that video. So you can just continue watching and click right through. I hope this video is helpful for you. If it is, please give it a thumbs up. That really helps me. Subscribe to the channel if you want more videos. But for now, let's get back to the contract, and we're going to start that off with the model release. All right, the model release. Every contract, if you're photographing a person, should include a model release. Again, not legal advice. The client hereby assigns the creator and its legal representatives, heirs, and assigns the irrevocable and unlimited consent to use the photographs and video of the client for editorial, trade, competition, advertising, education, and any other purpose, and in any other manner or medium, to alter the same without restriction, and to copyright the same without restriction. This means that my work and my body of work can carry on after I die. I can use my images however I want, my images that contain people in them and the people who have consented to and signed my contract. So if I wanted to publish a book of images I've created, then I could do so. I would not have to compensate the people in the book for the images of them. If I want to sell prints of people, or if I take a photo and I want to sell it as artwork, they aren't going to be compensated. It's my work and it's a representation of me and the work that I do, and it is being presented and sold, capitalized on in a way that I, as an artist, see fit. The client releases all claim to profits that may arise from use of images, any right to payment, royalties, or any other consideration for creator's use of such images. Client hereby agrees to release and hold the creator harmless from all claims and demands and causes of action which client, its contractors, and their heirs representatives, executives, administrators, or any other persons acting on client's behalf or on behalf of the client's estates have or may have by reason of this authorization. If somebody dies and maybe I've photographed somebody well-known, a celebrity or personality, and they pass on and their image is used maybe in a collection of images sold as a magazine. That means the people who inherit their estate don't have any claim to money that I as an artist have made from that work, in the same way that the client had signed that away. They're saying that, yes, I give that, and also don't ever expect that my children will come after you or the executor of my estate or anybody else who represents me. You're free to use the images however you wish. Artistic style. I have an entire video on this called the Spielberg Clause, and here's what it says. On its own behalf and on behalf of the subject, client acknowledges that it is familiar with the creator's portfolio and is requesting services with the knowledge of the creator's style, that the creator's work is constantly evolving, that the creator's services are of unique and artistic nature, that the photos may be different from photographs taken by the creator in the past, and that in creating the photos, the creator shall use its artistic judgment to create images consistent with its personal vision of the event, which vision may be different than the client's and for the subject's vision of the event. Accordingly, the client acknowledges that the photo shall not be subject to rejection on the basis of taste or aesthetic criteria. The final post-production of editing styles, effects, and overall look of the images are left to the discretion of the creator. That means your client cannot reject your images because they thought they were going to be getting something that looked like a past session that you've done. And maybe you've evolved as a photographer. You evolve as a photographer after every shoot that you do. You are continuing to grow and to develop as an artist, as a creator, a craftsperson, every time you take a photo, and you are evolving. And this paragraph is the client acknowledging that you as an artist, as a creative, are evolving, and that they are hiring you because they trust your artistic vision, not because they want you to replicate something that you've done in the past. Oftentimes that's the case, but they can't reject the images on the basis that they don't like them. So they can't just say, we don't like the way this looks, we're not paying you. So this clause is in there to protect you on that grounds. Copyright and licensing. Under the laws of the land, the copyright of all work created by the creator remains with the creator. You own the copyright, and they're acknowledging that the laws of the land, in my case, the Canadian Copyright Act, says that all the work that's being created is mine. The person hiring me does not get the copyright of the images. The work produced by the creator is property of the creator, protected by federal copyright law, and may not be reproduced in any manner without the creator's explicitly written permission, outside the confines of what is permitted under federal copyright law. I own the copyright. They can't just do whatever they want with the images, and they need my written permission to do so, and I will charge them for that permission. The creator shall retain copyright in all the material produced by the creator, and this right shall accrue to the benefit of his or her successors, legal representatives, and assigns. So if I die, the people who come after me, my children, if I had any, would inherit my copyright up until the point where that copyright expires and the work becomes public domain. Sale of the images by the client is strictly prohibited. So I take images, the client cannot sell the images that I create. All work created by the creator and the associated copyright is the sole and exclusive property of the creator. Grant of any reproduction rights to the client is conditioned upon receipt of payment in full from client. This means they do not have the right to use the images until I have been paid in full. If they have not paid me, they cannot use the images. All rights not expressly granted shall be reserved by the creator. That means if I have not given you the right to use an image in a specific way, such as out-of-home use, then you cannot use the images in that way unless you pay me for usage under those terms and conditions. Modification of work and or incorporation of work in any layout or concept shall not constitute a joint work or derivative work. This is important. This is an indemnity clause. If my images are used to, say, promote, God forbid, fascist or Nazi propaganda, and someone decides to sue that organization, I, as a photographer, am not seen as a contributing person to that layout or that design. I am not creating a joint work with these people. I am not to be held liable for how they use the images. All licensing options quoted are valid for 15 days from work delivery date. If I give them a quote, then that quote is good for up to 15 days from the date the work is delivered. If payment is delayed, then terms and payments, the cost, the quote can be changed and renegotiated. Likely won't be, but that's what that means. Client and or agency hereby indemnifies and holds creator harmless against any and all liabilities, claims, and expenses, including reasonable attorney's fees arising from clients' or agents' use of the work. This is the indemnity. So again, if there's a claim or something that the client uses my work and they get sued for something, for the message, as an example, constituted as hate speech, then I am not tied to that. I made sure that I'm indemnified from their use of the images. Reservation. A signed contract and fee are required to reserve the dates and times of the event. If the event is rescheduled, postponed, or canceled, or if there is a breach of contract by the client, the fee is non-refundable and shall be liquidated damages to the creator. This term, liquidated damages, is incredibly important. Liquidated damages means that any money that they have given me is to be considered damages that they cannot recoup, damages that they have caused my company, and the money from their perspective has been liquidated and they do not have access to it anymore. Again, I'm not a lawyer. Liquidated damages probably has a more specific meaning, but if you do not have those two words, if I do not have those two words in my contract, I do not feel good about my contract. The client shall also be responsible for payment for any of the creator's materials charges incurred up to the time of cancellation. So if I have to order equipment, if I have to order backdrops, seamless backdrops, or if I have to order props, things like that, if I have to buy things, I'm not going to be on the hook for those costs and those expenditures. Those costs the client will have to pay for. If the client has purchased digital image proofs from the creator grants the client permission to share the images on social networking site and with family and friends. Client is not allowed to provide images to other vendors or contractors. For example, in the case of like a wedding, if I give you images for your wedding, you can't just give those images to the vendors, the florist or the venue. They don't have a right to those images. You, as a client, cannot just give out my work to other people to use for free. That's not how copyright works. I have the copyright. For example, if you're an interiors photographer and you come and photograph the work of an interior designer, but they hired someone who does like incredible millwork to work on a fireplace or do some amazing doors, they can't give your images to those businesses to use to promote their work on their social media platforms. Those businesses would have to license the images from you for their use of the images. So you could take an image and then that image you could get paid by the interior designer, you can get paid by the architect, you could get paid by the person doing the millwork, you could get paid by the mason. There are a lot of people who may want to license your images to help promote their business. They cannot just take your images for free, not pay you, and make money from your work. They can't do it, and you should not allow it. Schedule. The client and the creator agree that cooperation and punctuality are essential to accomplish the goals and wishes of all parties. Shooting commences at the scheduled start time. If the client does not arrive at the appointed time for the event, shooting will commence at the scheduled start time. All additional time beyond the scheduled time will be billed to the client. Notification of any changes in the event schedule or location must be made in writing in a timely manner, and confirmation of receipt must be obtained from the creator by the client. This contract covers the hours specified on a continuous basis. So if you book a shoot with me that is 3 hours long and you show up an hour and a half late, don't expect to get a 3-hour shoot. You have booked 12 p.m. to 3 p.m. You are getting 12 p.m. to 3 p.m. One of the reasons that this is included is this could be used for a wedding, but it also could be used for a commercial shoot. On commercial jobs, if the job runs over, then we have to pay overtime. You have to rework the estimate, and the client needs to sign off on that overtime. But that's what has to do, or they'll have to trim back and scale back what they're getting in the end. If the time is exceeded by the client, I don't have to then allow them to be late and honor the 3 hours. I have to honor the time that they booked. If you are doing minis and people can book on the half hour, so at noon, 12:31, 1:32, 2:30, and somebody has booked a time for 1 p.m. and they show up at 1:15 expecting a 20 or 25 minute session, but you have somebody coming at 1:30, they get a 5-minute or 10-minute session. That's it. Cancellation and postponement. The client acknowledges that in the event that there is a postponement of the event, the creator will be harmed. You will have caused me harm by canceling or postponing the event, financial harm, and that the client will notify the creator of a postponement as soon as possible in order to minimize the creator's damages. If a wedding is canceled or postponed, the date is changed, that's going to affect you. If any shoot that you are doing, if the date is canceled or postponed, that can cause you harm. If you're shooting work in which you need that time to go somewhere else, if you are shooting advertising work but you have a lot of leeway in your schedule, be an accommodating person and an accommodating professional. Safety. The creator reserves the right to terminate coverage and leave the location of the event if any person from the creator experiences inappropriate, threatening, hostile, or offensive behavior from persons at the event, or in the event that the safety of the person from the creator is in question. The client will not be entitled to any refund, and the client will agree to relieve and hold creator harmless as a result of incomplete photography coverage or for a lapse in the quality of work. So that means if someone is getting up in my face and threatening me, for example, when I was shooting weddings, if a guest was drunk or not drunk and being inappropriate towards an assistant, and that assistant felt like they were no longer comfortable being present at that event, then I would allow them to go home, and that would not affect my contract or my coverage. Or if I feel threatened, I am allowed to leave the space so that I am no longer in a position of threat. The client cannot sue me. They can sue me, they can try, but they're not entitled to any refund if I have to leave an event because I do not feel safe. That doesn't need to be threatened either. That could just be the conditions on the job site are unsafe as well. If I don't feel safe and I wish to leave, I can do so without any financial harm being caused to me. So this just communicates with your client that safety is a concern, and it should be a concern for them as well. Permits. This one is pretty simple. When required, the client is responsible for acquiring all permits and necessary permission for all locations on which the creator will be performing services. The creator will notify the client of any permit requirements by the creator within 2 business days of discovery. So if you book me for a shoot and you want it to be at a specific location, but that location requires a photography permit, I will notify the client within 2 business days of discovering that a permit is required. The client can then decide if they want to pay the permit, and they will have to handle that on their own. I'm not going to handle that. That's their responsibility to get the permit, and then they will take care of that. That's something that they need to pay for. I don't want that funneling through me and for me having to deal with that. Not on a portrait shoot. On a commercial shoot where everything funnels through me, completely different story. Location permits, everything. I end up handling all of that unless there's a producer on the client's side who's producing the shoot and will be handling all of that, which is the way things tend to be going these days. Responsibilities. This is a big part of a contract. The client or agency is responsible for the presence of an authorized representative at the shoot to approve the creator's interpretation of the project. If a client or agency rep is not present, the creator's interpretation shall be deemed acceptable. Those people need to be on location if it's a commercial shoot. If they're not on location and they're not sending a client representative representative or an agency representative. If the client's not going to be there, then they are agreeing that my interpretation of what I am photographing is fine. They have every opportunity, not even an opportunity, they have the responsibility to be present and to be part of the process. The creator is not responsible for compromised coverage due to causes beyond the control of the creator, including but not limited to the lateness of the client, weather conditions, schedule complications, incorrect addresses provided to the creator. It happens. The client's physique or the client's self-image. The creator is not responsible for photos that are not completed due to the possibly uncooperative nature of the individuals to be included in any photographs. In a family session, if someone's not being cooperative, children can be very uncooperative, and then it is not my responsibility as a photographer to get images of an uncooperative individual, whether that person is a child or an adult. I have also included in here that I'm not responsible for compromised coverage that is due to the client's physique or the client's self-image. This means that they cannot reject the images on the basis of the fact that they don't like how they look in the photos. The creator is not responsible for backgrounds or conditions beyond the control of the creator that may negatively impact or restrict the photo coverage. The creator is not held liable for any coverage expectations not communicated by the client to the creator in writing and agreed upon by the creator in writing. The creator reserves the right to discard any images that are not deemed presentable. Discarded images are not available to the client at any time. This is when your clients say, hey, I want to see all of the photos. I want the raw photos. You don't have to give them to them. You should never give them to them anyways. Discarded images where their face looks like, throw them away, delete them, get them off your hard drive. You're never going to use them. You're never going to look at them. The line here that says the creator is not held liable for any coverage expectations not communicated by the client to the creator in writing and agreed upon by the creator in writing is an example of how when I did a shoot and I photographed people the way that I normally would, which is now why the artistic style clause is in there as well, because they wanted things shot in a way that they did not communicate to me. Yeah, they can't hold me liable for that. You didn't tell me you wanted things done in a specific way. That's their responsibility as a client. That's why it's in here in responsibilities to tell me what they want, what they need, and to communicate that to me clearly. I'm not a mind reader, so what I'm going to do is I'm going to create images the way that I normally create them, and if they don't like them, it's their fault for not communicating what they were looking for. In the unlikely event that digital files have been lost, stolen, or destroyed for reasons beyond the creator's control, including but not limited to camera, hard drive, or equipment malfunction, the creator liability is limited to the return of all payments received for the event. If, God forbid, you get into a car accident and the cards are destroyed, then I would only be responsible for returning the payments that I had received for the event. I wouldn't be responsible for any further damages beyond that. The liability is limited. The limit of liability for a partial loss of original shall be a prorated amount of the exposures lost based on a percentage of the total number of originals. So if I'm photographing over 5 cards and one of the cards gets corrupted, I'm not responsible for 100% of the shoot. I'm only responsible for 20%, assuming an equal number of exposures across all the cards. But, obviously we have measures in place to mitigate that and to make sure that we have redundancies for our redundancies so that never happens. The creator is not liable for the loss of images beyond the lesser of the final delivery of all products included in the package or 1 year. If after the images are delivered or after a year, the images are deleted from a hard drive, I'm not responsible for maintaining an archive of the images that I've created. Post-production and retouching. Work will be delivered in a timely fashion within a mutually agreed upon schedule. Any additional retouching requested by the client or agency beyond the scope of the job description will be quoted on a case-by-case basis. That's it. I'm going to deliver your images to you on time, and if you want additional images and additional retouching, I will quote that on a case-by-case basis. I mean, it's self-explanatory, this one. Storage of files. Once the files are delivered to the client, it is the client's sole responsibility to protect and retain their images for the future. It is highly recommended that the images be duplicated and stored in multiple locations. All digital files are only guaranteed by backup storage for 6 months from the event date. After that time, the creator will not take responsibility for any potential loss of digital files for any backup solution publications used by the creator. So that just means after 6 months, I'm no longer obligated to store their files. I will do it for 6 months. I never delete anything, but if something happens and I have accidentally deleted an entire month's worth of photos and I managed to get some of them back, that's the reason I've developed a backup system that is multiple redundancies. I have a video on that too, which I will link to in the comments, and you can watch that as well. Non-disparagement. For the purposes of this section, disparage shall mean any negative statements, reviews, comments, or feedback, whether written or oral, about the creator or services provided by the creator. Client agrees that they will not disparage the creator or post any negative statements, reviews, comments, or feedback about the creator or services provided to any third party, whether orally or in any written publication or online forum, chat room, or message board, including but not limited to Google, Facebook, Twitter, TikTok, and Yelp. Parties agree that it would be impractical and extremely difficult to ascertain the amount of actual damages caused by a failure to comply with this provision. Parties agree that in the event it is established that the client has failed to comply with this provision, liquidated damages shall be payable. That means you can't trash me. If you don't like your images, you can't just go and trash me on social media, which is what the worst client of mine that I've ever had, they threatened to do. It was 2 women, real estate agents. They did not like their images, but they threatened to go destroy all of my social medias and review bomb my page because they failed to communicate to me how they wanted to be photographed. They just threatened me. They extorted me, and I have a lot of paperwork and I have an entire file from that specific case. So this entire clause exists because of that horrible client that I had. Pricing. Services or merchandise not included in this initial contract will be sold at the price current when the order is placed. All prices are subject to change at any time without notice. Prices for all work, services, and or product are in Canadian currency. It just means all my prices are in Canadian dollars. My prices can change, and if it's not in the contract, my prices can be different if you want to do something in the future or buy more images. If it's not outlined in this contract what the prices will be, then they're subject to change. Inflation's been crazy, so prices have had to go up. Payment. The client agrees to pay the creator according to the amounts and dates outlined in the payment schedule above. Remember at the beginning I showed you that there's a payment schedule attached to the contract. In the event the client fails to remit payment as specified, the creator shall have the right to immediately terminate this agreement with no further obligation, retain any monies already paid, and not attend the event. If you don't pay me, I'm not showing up. Client's failure to pay the final balance shall be deemed a material breach of this agreement, shall result in damage to the creator, and shall relieve the creator from performing any services under this agreement. So if you don't pay me and my final payment for larger contracts is due prior to me shooting, you don't make that payment, don't expect me to show up. Don't expect people to pay you afterwards. On commercial shoots, you're going to be looking at net 30s, net 60s, but this is a portrait contract, so this is what I'm dealing with consumer clients. Payments can be made via electronic bank transfer, credit card, check, or bank draft. Payments via credit card and bank drafts will be considered paid upon receipt. Payments via check will be considered paid upon clearance at creator's financial institution. Just because you hand me a paper check does not mean I am going to consider the contract paid or the shoot paid. It will only be paid once the check clears. If you give me a bad check and it doesn't clear, the session's not booked. The session's only booked when the money's in the bank. Returned checks will be assessed a $100 non-sufficient funds fee. If you bounce a check on me, it's going to cause me a lot of problems, take me a lot of time to deal with. So what I try to do now is do electronic fund transfers as much as I can instead of getting paid by check or bank draft. If you do pay by check or bank draft, make them payable to Kevin Patrick Robbins. Travel to remote locations. A remote location is defined as a location with a distance further than 100 kilometers from creator's address. My address is at the top of the contract. If the distance I'm traveling is further than 100 kilometers, then there are going to be travel fees attached to that. All travel expenses are based on the distance between the event and the creator's address. The client is responsible for all travel, accommodation, meal, and transport costs unless provided by the client. So if the client is not feeding me or providing me with a location to stay at, for example, if I was going to photograph headshots at a conference and they were supplying me with a hotel room, that's fine. But if they weren't supplying me with a hotel room, then they would have to cover the costs of me renting a hotel room. Client agrees to reimburse creator for any travel travel-related out-of-pocket expenses that have not been provided by client, and that will be itemized on final invoice. That might include a per diem for me to eat. Client will reimburse creator for round-trip air transportation unless assignment is better served by utilizing the creator's vehicle, in which case customary travel and fuel charges apply. On-site transportation and accommodation while on remote location, including 1 day prior to production and 1 day after production. For example, if production days are scheduled for Monday, Tuesday, and Wednesday, accommodations will be made for check-in on Sunday and check-out on Thursday. If I have to fly somewhere, the client is paying for it. What I will do is I will book the flight, then I will bill that back to the client. That's a better thing for me to do. The credit card that I can use would gather points for me. All fuel charges will be invoiced at 150% of the Canada Revenue Agency's reasonable per kilometer allowance rate for the year in which the event takes place. You just Google reasonable per kilometer allowance rate, Canada Revenue Agency. If you're in Canada, if you're elsewhere, then your government would probably have a reasonable per kilometer allowance rate or per mile. Termination by the creator. In addition to any other obligations set forth in this agreement, upon termination, if creator terminates this agreement for any reason other than breach by client, creator will refund any unearned fees to the client that had been paid to the creator as of the date of such termination. So if I have to terminate the shoot, I will have to refund any of my unearned fees. If I cancel, then I have to refund the money. For example, if this were for a wedding and I decided no longer wanted to work with this couple, then I would have to refund their money to them, obviously. Or if something came up, I knew that maybe I was going to have surgery and I would no longer be available to photograph, I would have to either refund or find someone else, which the next part of this says, in the unlikely event that the creator is unable to perform the guidelines of this agreement due to, but not limited to, injury, illness, or other cause beyond the control of the creator will make every effort to secure a replacement. If I have to go in for surgery, I hope not. If something like that were to happen, then I would find someone to do the job for me instead of just canceling and doing the refund. Then, of course, I would pay that person who did the job for me. If the situation should occur and a suitable replacement is not found, responsibility and liability are limited to refund of any payments received for the event. If I have to cancel and I can't find a replacement, then the liability that and exposure that I am limited to is just what has been paid to me. For example, if it were a wedding, the couple could not then sue me for further money beyond what they had paid me. I just have to pay them back, and that's it. Termination by the client. The client acknowledges that in the event that there is a cancellation of the event, the creator will be harmed, and the client will notify the creator of a cancellation as soon as possible in order to minimize the creator's damages. If there is a cancellation, the creator and the client agree that the client shall be responsible for the payment to the creator within 10 days of any cancellation as liquidated damages, there's that term again, and not as a penalty. Money is paid to the date of the cancellation, which represents a compromised portion of the actual damages sustained by the creator due to a cancellation. This sum shall be in addition to any retainer paid. If the client terminates, the damages have been done. I need to recoup my costs, I need to recoup my expenses. The money that they are paying to me or have paid to me will not be returned, and it is not a penalty. It is just that they have damaged my financial stability. They are compensating for that. Force majeure. This is a clause and a term that we all came to know and love when COVID hit. Neither creator, client, nor agency shall be liable for failure of either party's obligations caused by any circumstances beyond reasonable control, including but not limited to acts of God, epidemics, pandemics, floods, riots, fires, civil unrest, acts of war or terrorism, or failure of energy sources. So if the power grid goes down, nobody's responsible for that. The client's not responsible. The client didn't cause the problem. I didn't cause the problem. The agency didn't cause the problem. Nobody's at fault. This is a force majeure, and it just means that nobody is liable for the failure of anybody's obligations. Collection. In the event that the creator is required to file a legal action to collect fees due from the client under this agreement or to otherwise enforce this agreement, then the creator shall be entitled to recover all costs and expenses incurred by the creator in relation to such legal action, including but not limited to an award of reasonable attorney's fees and legal disbursements. This basically means if I have to hire a lawyer or a collection collection agency to hunt you down and get the money from you as a client, then I am also entitled to be compensated or reimbursed for the fees that I have to pay to a lawyer. And finally, this is the last clause, and you will need to customize this for your area and region, and that is the jurisdiction and venue. This agreement shall be construed according to the laws of the province of Ontario and the nation of Canada. That's where I live, and that's where I work. The client acknowledges that this agreement was entered into in Hamilton, Ontario, and that at least a substantial portion of this agreement will be performed in the country of Canada, and that the proper venue for any legal action related to this agreement is in the Superior Courts of Canada. If somebody wants to sue me, then the jurisdiction will be in Canada, in Ontario, and the agreement was taken into effect in Hamilton. This is an issue with contracts that you might find online and just borrow the text from, but not customize. Especially in the US, if you get a contract that says the jurisdiction is California and you live in Virginia and there's a legal dispute, you're going to have to go to California because that's what's in your contract as the jurisdiction, and you will be subject to the laws of California as opposed to the laws of Wyoming or Virginia or wherever it is that you live and the event has taken place. So make sure that your contracts list a jurisdiction and venue, and make sure that that is local to you. Look, this was a long video, and I'm glad you stuck around. I really appreciate it. If you found this helpful, please subscribe to this channel. It really helps me out. Hit the like button. What I would love to know in the comments, what clauses do you have in your contract that you think that I've missed out? Especially let me know if you're a lawyer. I mean, I know it's not going to be legal advice, but I definitely want to hear your thoughts on this contract and on the terms and conditions that you have in your contract. Thanks for sticking around. Have a great day.